Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, a partner at the immigration, medical malpractice, and business litigation law firm Kurzban, Tetzeli, and Pratt, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Serenade e-Immigration. All right, here's a quick favor you can do for yourself. If you're even thinking about your case management setup, go take a look at this. E-Immigration is offering listeners of the podcast a free demo, and when you book through the podcast link, they'll donate $25 to Casa Cornelia Law Center in San Diego. And yes, there's a bonus. Everyone who signs up will also get a free upgrade from the Essentials package to complete. It's a win-win, so go to get.eimmigration.com/IRP. Check out a ton of free resources and book your demo today. Or of course, click on the special link in the show notes. This podcast is also sponsored by Gonzalez & Gonzalez Immigration Bonds. Immigration attorneys. Once you've secured a bond, let Gonzalez & Gonzalez take it from there. In business and family owned for 75 years, Gonzalez & Gonzalez helps other families post immigration bonds quickly, easily, and with full support every step of the way. Sure, you can post directly with DHS, but that means no guidance, no help when something goes wrong, and a 4 to 6 month wait for a refund. With Gonzalez & Gonzalez, families get hands-on help throughout the entire process and typically get refunds within 1 to 2 weeks of receiving the I-391 notice. Tired of being the point of contact for every bond question? Let Gonzalez & Gonzalez take those calls. They'll handle the paperwork, the system issues, and the family's concerns, so you can focus on what really matters, winning the case and helping your clients stay in the country. You can reach Gonzalez & Gonzalez at 833-409-9200. Their fee? Just 2% plus $40, and for bonds of $10,000 or more, they can defer the fee and deduct it from the refund. Financing options? They've got those too. Give Gonzalez & Gonzalez a call, check them out at immigrationbond.com, or click on their special link in the show notes. And as always, this show does not constitute legal advice and is intended to keep you up to date and enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. In this special episode, we again have the man, the myth, the legend, the legion, and the Legionnaire's disease, Ira Kurzban. Also the founding partner of our law firm, KKTP, and a man who has the 20th edition of his source book coming out this fall. He's back again to do his annual Supreme Court Roundup. The gloves came off, folks, as they always do. Strap in to learn. I hope you enjoy. Ira Kurzban, welcome back again to the Immigration Review podcast. This is like the third or fourth year in a row that we've done our Supreme Court Roundup. Thank you so much for being here.
It's amazing. Thank you, Kevin. It's always a pleasure to get to have my thoughts broadcast all over America.
If I could do nothing else with this podcast, it's to spread Ira Kurzban thoughts all throughout this land on the Supreme Court. And there's no one better. And quite frankly, you say a lot of the things that a lot of us want to say, and you're willing to say it. And you've read all the decisions so you can say it. So glad to have you back.
Thanks a lot. It's a pleasure. And the show is going great. I hear good things about it every day from people. So it's entertaining and interesting.
Well, thank you for that. But, if you're plugging it here, by definition, people are already fans because they're listening to this episode. So when you go on other shows like CNN or whatever, feel free to plug it there. Feel free to plug it at all those other events you go to, Ira. That would be wonderful.
My pleasure.
Last year and the year before, you talked about a lot of cases, and there are a lot of cases, and you read all of these cases, and people had wonderful feedback about it because we're not reading all these cases, a lot of non-immigration, immigration adjacent. This year, you've selected less but want to go in depth a bit more. Is that right?
Yeah. Not only want to go in depth, but, the Supreme Court took less cases,
Right.
although not necessarily less immigration cases, but they're a court that appears to be, at least in terms of the six, very focused on where they want to move the country and what kinds of cases they can take that will move the country in a sharp rightward direction.
Before we get going, I'm pretty bugged about this. I don't like the fact that we've been calling these justices, and certainly some of them conservative, that Donald Trump can be called a conservative. It seems like there's something else. And it seems like by calling it conservative, you're giving this veneer of political legitimacy and intellectual legitimacy to what seems to me to be quite reactionary. I don't know if you've thought about this at all.
Well, I would call them the Gang of Six, except I might get into some trouble. It is clear to me that they act more and more as a political force and really less and less as a legitimate court in the sense of, as Chief Justice Roberts said when he sought the appointment as Chief Justice, we're just calling balls and strikes. You certainly don't get the feeling reading some of these opinions that they're just calling balls and strikes. And it's just how shall I put it, an effort to really reach the core of what the issue's about rather than pushing the country in a particular direction. And part of that, I think, stems from their view of the unitary executive. In fact, I think a good deal of the problems that we're seeing stem from that view, stem from the view of a number of them. And I think it comes out most viscerally, by the way, in Trump v. Slaughter, in Justice Gorsuch's opinion, his concurring opinion comes out very viscerally as anti-administrative state. As a young lawyer, there were people who used to say, we want to shrink the administrative state to such a degree that we can drown it in a bathtub. And they're going about the business of doing that now. I think if you look at the kind of hubris in seizing power for judges that you see in cases like Loper Bright, where the minority Justice Sotomayor and Justice Kagan, I think, have pointed this out in a number of cases, and Justice Jackson. So you see, looking at kind of the overall picture, you see a couple of things happening. And one of those things is the substitution of judges instead of having experts, as we always have had in agencies. That's what Loper Bright is really about. It's saying we're not going to defer to agencies anymore. We, federal judges, know more. I don't know. They obviously don't in any particular area of expertise, but that they are going to make those decisions, and the idea of deference is inappropriate. The third part of this is, as I think was made clear in Trump v. Slaughter, is the idea that we don't need people with expertise anymore, that the federal government, under this theory of unitary executive, which I don't think the Constitution ever imagined. Jamie Raskin, I thought, wrote a very interesting piece recently in Nation talking about how Article 1 is the article for Congress. In other words, when the founders were thinking about what to do in America, who did they put first? They put the Congress of the United States, not the executive. And the executive is there just to carry out the laws that Congress makes. They've really flipped it on its head now, in effect, by saying in the unitary executive theory, the executive is all powerful. And, we can talk about this as we go through the cases, but it's clear to me that if you look at Trump versus the United States and you look at cases like Dahlia Doe and Mio this term and Trump v. Hawaii previously, what is the six judges really doing? And what they're doing clearly is emboldening an executive to basically control everything so that anyone who works for the executive branch no longer has to have expertise, no longer has to have any history about what they're doing. They simply have to follow a loyalty oath. And if you think I'm making that up, and I have already been told by former officials of ICE that when people go in now and are seeking jobs at places like ICE, they are asked, who did you vote for? Are you a Democrat? Are you a Republican? Are you a MAGA Republican? And so what we're creating in the United States by destroying the administrative state is something that looks very authoritarian. And I'd like to start off today talking about the most important case, which I think of the term, and probably in my view, other than cases like Brown versus the Board of Education and a few other cases, probably the most important decision in the last century in immigration, which is Trump v. Slaughter.
Before getting into the aptly named Trump v. Slaughter decision, horrifying podcast this is going to be as always, but that's because of the Supreme Court. I promise listeners, if you get to the end, we're going to have some uplifting things. So Ira, be thinking about that over the next hour. But I guess that's my point. Before getting into Slaughter, which we'll start off with, Jarcasi and Loper Bright, of course, for last term. We're not going to get into those cases, but they are very important for these cases this term. But, Trump v. Slaughter vacates Humphrey's executor, right? That's what you're going to talk about. And if you've got a Supreme Court vacating 100-year-old precedent, that's not conservative. That's my only point. And with that, let's I'm going to keep thinking about the title for what these justices are, and please tell us about Trump v. Slaughter, Ira.
Okay, so Trump v. Slaughter was decided on June 29th. As I predicted, Chief Justice Roberts would do what he did the last year, which is Trump-like, put in so many different decisions, most of them horrible, in a very close time period so that people don't know which way to look in order to determine how bad things really are. And for example, I think Trump v. Slaughter is a good example of that. Everybody was looking at birthright citizenship. If you're an immigration lawyer, what's going to happen with birthright citizenship? And yet, in my view, Trump v. Slaughter was the most important case of the term. And even more important, I have to say, than the case we worked on, Dahlia Doe and Mio, although that was wrongly decided, Allo Trolato, that was decided, all very troubling cases. But Trump v. Slaughter has implications that are far, far broader for the entire administrative state. Basically, the case arises out of the firing of one of the members of the Federal Trade Commission. And the original case on this, which dates back 91 years, where the court said during really the Roosevelt era, where there was a decision called Humphrey's Executor versus the United States. And Humphrey's Executor basically said that, if the agency builds in, the Congress directs the establishment of an agency, and you can only fire people for cause in that agency, and that is kind of the protection the long-term and short-term protection that people have working for the government. And it was a way year after year after year to create other agencies, the FCC, but all the agencies of the federal government, including the Department of Homeland Security, including USCIS. Why do people go and work for the government? They have some sense of security. They develop expertise over the years. They develop an historical perspective about the agency and so forth. Trump v. Slaughter basically says everyone now works for the President of the United States. They all work at his pleasure. It doesn't matter any longer for cause or not for cause. You can fire somebody. And you might think, well, you can always go to the Merit Systems Protection Board. Say you're an officer at USCIS, or you're an immigration judge who has a 60% approval rating of asylum, where now they're denying them at 92%. That's the current rate. You now have to worry about just being fired. They can come in one day and say you're fired. We've known this over the last year and a half by the firing or the displacement of over 200 immigration judges, but now they can just ask for a loyalty test. Before they hire somebody, they can ask them, who did you vote for? Do you support all of the president's policies? Do you support all of Miller's policies? If you don't support them, we don't want you here. We don't want you as an immigration judge. And those judges that are remaining there now are subject to the dictates of Trump v. Slaughter and can also be fired. Well, you would think, okay, you can go to the Merit Systems Protection Board. You didn't do anything wrong. But it turns out that the Merit Systems Protection Board is also subject to people being fired without cause. And indeed, one of the cases that was seeking certiorari, which the court turned down, was a case in which somebody was fired from the Merit Systems Protection Board, not for cause. And they sought review of that. It was denied below. They lost below, and they sought review in the Supreme Court, and the Supreme Court turned down the case. So we now have what any autocratic government would have, in effect. That is, a president or whoever it is, in this case Trump, can now make all decisions of every agency. So the first thing you have to think about is, what does that do to America? I mean, forget about immigration alone or anything else. What happens if you are a highly qualified scientist working for CDC or the National Institute of Health, you're a doctor, or you're working for the Food Administration, or you're working for the FAA, and you're looking at, plane crashes. And they come to you one day and say, well, you didn't vote for Trump, you're fired. What's the incentive now? Forget about the people being fired. What's the incentive for somebody else who's truly has great technical expertise looking at the possibility of working for the federal government? The answer is you'd kind of be crazy to, right? I mean, unless you were a Trumper, I guess now. So in that sense, Trump v. Slaughter is it not only puts us back, I think, 100 years, almost 100 years, to Humphrey's executor, but does something far, far worse. In a competitive world where the president claims we're, competing against China and we're competing against Russia and competing against Europe now, for expertise and everything, somebody who's an expert would be foolish, really, to go work for the federal government unless they strongly supported Trump's view of the world. And that's the most troubling part of this. The second part, to show you, and then I'll stop talking about Trump and you can ask me some questions, Kevin. But the second part that's troubling about it, and you can read this in Justice Gorsuch's concurrence. And I would recommend that everybody read that as well as the Chief Justice's opinion, and as well as the dissent in the case by Justice Sotomayor, and I'll quote her dissent in a minute. But Justice Gorsuch, you can tell. And, people always say, well, he's really upset because his mother was at the EPA and she had lots of problems there. But whether it's generated by that or generated by his own personal views of the unitary executive, it is in my view, a frightening understanding of how the federal government actually works, because he really wants to tear it all down if you read this opinion. And in the end, he says, well, if Congress can't legislate this, then it'll just have to be left up to us. We in the courts, and this is what I meant before about the hubris of the courts now going to make these decisions as to what should happen in any individual agency at any time. In contrast to that, and very interesting, was Trump v. Cook. Trump v. Cook was the firing of the person who works as a member of the Board of Governors of the Federal Reserve. And for some reason, they said, well, this notion that we have now ordered really in Trump v. Slaughter really doesn't apply to Ms. Cook because she works for the reserve, Federal Reserve System in the bank. And I think rightly, some of the people who joined on Trump v. Slaughter basically said, well, why make an exception for them? It should be anybody who's in the federal government at all. We only have 3 branches of government. Gorsuch's whole opinion is about how this administrative agencies have become the 4th branch of government, and they really, I think if you read between the lines, they must be destroyed. And if the Congress can't legislate, then we must come forward and make all these decisions. Very anti-democratic in my view. But in Trump v. Cook, they make the exception. And of course, people have said, why is there an exception for the Federal Reserve? And, the Chief Justice again tries to give a detailed history as to why there is an exception. But if you believe in the unitary executive, unless he's just trying to protect financial interests. So in the end, looking at this from a global perspective, what's really going on? For the financial system, we're going to make an exception. But for all the rest of us, the people who are affected because in the work environment, OSHA doesn't really exist anymore, in terms of furthering the protection of workers, or because now the president has decided DEI is the enemy and we've now taken away any real meaningful struggle about discrimination, and you can go agency by agency and do that. But for some reason, we will protect the financial institutions because that affects the billionaires in America. That affects maybe people's 401k as well. But the point is, why make an exception for them? What about the rest of America where people are suffering or in poverty, or they now have no protection? It's just up to the whims of the president. And then finally, just on this point, I want to read the conclusion of Justice Sotomayor. She says in Sotomayor's opinion, what is this really all about? She says, no, there's no 4th branch of government. It's been an ability. First of all, historically, there was never anything in any historical documents that would support the notion that for cause should not be included in any agency of the government, and that people can just be fired at whim by the president, just as if he were a king, and just fire anybody he wants. That was not what the founders intended, and there's nothing to indicate that. So having a unitary executive doesn't mean that the president becomes a king, that he can just do whatever the heck he wants. And so in conclusion, she writes the following. Today, the court discards the democratic regime in favor of one that distorts the structure of government to fit the majority's theory of unitary, total executive control. The result is a president who emerges with far greater power than ever before. It is a power, however, that neither the people, nor Congress, nor the Constitution bestowed upon him. In granting the president this unbridled authority, the court upends its precedent, meaning Humphrey, misconstrues our history, meaning going back to George Washington, what his perception was of what the executive really was and what the founders thought the executive should be, and sheds any pretense of judicial modesty. Going back to what I was saying before with regard to the judges now deciding they are going to in a way, run America if the Congress doesn't step forward. So Trump v. Slaughter is a huge problem, and it works two ways, by the way. Let's look at a Democratic administration in 2028. Let's say they win. Well, the president can issue an opinion the first day that says every decision of the Board of Immigration Appeals that was made from January 2025 to 2028 is now void. And direct the Attorney General to vacate all this, because after all, the Attorney General serves at the pleasure of the president. Or they could say something like any immigration judge, from our perspective as immigration lawyers, any immigration judge, anybody employed by ICE after January of 2025 is fired today. Anyone who worked for the agencies but left before that date will now be reinstated with full back pay for all the time they lost. And they can do that with every agency, apparently. So now we'll have, complete chaos in how our government is run. That alone is what the 6 justices have now done to the United States government.
That was a lot.
That was
very, very important decision, obviously. Two things come to mind on what you were saying. First of all, I don't know if you get the Atlantic, but early on in the Trump administration, they had this great article, I guess, but it was really just profiles on like 50 people who were fired from the various agencies and how important they were. And, the USAID, Department of Labor, you name it, every single department. And it was so maddening. I actually started tearing up at the amount of expertise and good people who were just cast aside. And most of them can get higher paying jobs. It's so insulting and scary for our country. What we lose. It was just a great piece in the Atlantic.
It is. It's truly frightening. I think this case, along with Trump versus the United States, have just upended our country in many, many, many ways. We're seeing it with Trump, who, is just doing whatever he wants to do. The corruption is rampant in this administration. He's already made they said $2.1 billion that he has put in his tax return. God knows how much more there is out there.
Trump v. United States, another one of those very aptly named decisions. The other thing that comes to my mind, though, is just the distinction on immigration judges. I'm sure you're right, but we're talking about independent agency heads in Trump v. Slaughter, right? There is still a statute that protects immigration judges, that protects USCIS officers, written by Congress. And I understand you talked about the Merit System Protection Board or whatever it is, and how maybe that's corrupted, fine. But also that's, as I understand it, just an exhaustion requirement before you can get into federal court anyway. There is still a statute protecting lower level employees, not historically at will or whatever you call them employees, be them immigration judges or USCIS officers. This doesn't necessarily mean that they can just be fired, that these Article 2 of the Constitution notes that these IJs got are lawful, right? Trump v. Slaughter's bad, but it hasn't resolved that question.
Well, I think to some extent you're right, but I think it's pretty clear the direction in which they're going. And if a case came back to them on a firing, let's say, of an immigration judge without cause, I think the result would be the same. I think they would say they all work for, and in fact, the agency takes that position. You know that, right? I mean, the EOIR takes the position that these are judges who serve at will and can be fired at any time. And so
they changed their rules, right? And this is just back to early 20th century, before all the reform, right? When you would have a new president come in, he'd put all his cronies in all of the agencies. It was just, we had an entire governmental revolution and put in all of these statutes to prevent this from happening. And then now we're right back to it.
Exactly. That's exactly right.
Who's trying to bring back 1898? It's just wild.
Yeah. I remember working on a campaign for a senator in Wisconsin, and I said to, no, I'm not that old. Okay. Close, but not that. No. I said, it seems like these real conservatives, they want to take us back to prior to the New Deal. And he said, no, you don't understand. They want to take us back to the 19th century. And he was right. And what you're saying is true. They really do want to have an America that looks a lot like the patronage system that we had. And unfortunately, the corruption. Because if a president can't be prosecuted for what could be his duties in office, and you can characterize these as duties in office, he got his new plane, right? He gets a $500 million or whatever it is plane that certainly looks in part like more than just a gift. And the question then becomes, he did it in the course of his duty as president. He got a new plane for the presidency. So under Trump v. United States, is that a core part of his duties as president?
Thank you very much, Ira. That was horrifying, but important for everybody to know. We need to be clear-eyed to maybe do something about all this. That's not an immigration case at all directly, but there were many this term that were. I've talked about all of them on the podcast, and you don't even have actually on your list. We've all forgotten about the substantial evidence past persecution case, right? The Reyes-Oriana decision, but that was also this term, if you remember. That was earlier. It's already been done on the podcast anyway, not a big one and not surprising at all anyway. So, the case that everybody wants to talk about, Trump v. Barber, the birthright citizenship, and then we'll get into the TPS case, of which our law firm has been involved since the beginning in 2018. So what's up with birthright citizenship? Has the republic crumbled?
Okay. The most obvious thing about Trump v. Barber is that one would think in this situation that there would be a 9-0 verdict or an 8-1 decision. The fact that we are one vote away from their saying that birthright citizenship doesn't exist under the 14th Amendment and can be altered any time by one vote. Remember, 4 justices on the Supreme Court do not believe the 14th Amendment covers all persons born in the United States, and it will depend on what Congress legislates or not. I thought the most significant opinion in this was not Chief Justice Roberts' opinion, which was kind of a tribute to the common law, but really devoid of any discussion about people. I thought it was a very interesting way of looking at it, but well written. But I think the opinion worth reading in all of this is Justice Jackson's concurring opinion, where she rebuts mostly Justice Thomas's view that this was only meant to protect freed slaves. And she does take a swipe at Justice Thomas by saying this is the person who believes the 14th Amendment is colorblind, yet only in effect, she says it in a roundabout way, but in effect only wants to protect black freed slaves and not anyone else, like immigrants and so forth. But in her opinion, Justice Jackson writes something that I thought was very interesting, which is she placed the 14th Amendment in the proper historical context as a movement by freed slaves who saw their struggle as part of a broader struggle for citizenship and freedom for everyone in the United States, in much the same way, although she doesn't mention it, that the Haitian Constitution in 1801 sought freedom and equality not only for black slaves, but for everyone in Saint-Domingue. And it did remind me quite a bit of what happened in the slave revolt in Haiti, and how after it, their constitution was for everyone, whether they were white, black, Native American Indians that had been slaughtered really by the French and then replaced by slaves. But the Constitution then and the 14th Amendment now for us clearly came out of this groundswell of desire to protect everyone. And I think that's worth a read if you don't want to slog through more than 100 pages of opinions by the justices. I also thought Kavanaugh's concurring opinion, which got it's really a 6-3 vote, but he only concurs in the outcome, saying that Congress has legislated this and Congress can change it. And I thought it was somewhat ironic that here's the person who voted for Dobbs v. Jackson, the anti-abortion case, because they believe that's what the Constitution meant by originally, to say that the Constitution is a living, breathing Constitution that can change over time, and therefore the 14th Amendment can change over time. So Trump v. Barber was important politically. I think it was typical of Roberts to try to position himself as much less reactionary than he really is by saving it for the end. And again, by kind of obscuring the importance of Trump v. Slaughter.
To put a pin in the birthright citizenship case, I mean, you have 5 justices that say the 14th Amendment says what it says, and you can't get rid of this. Should be 9. Justice Thomas and Alito doing crazy stuff. But Justice Kavanaugh saying Congress could change this because it's not a constitutionally protected right. So you don't have 5 justices for Congress can change this, but yet it creates this talking point that is already being talked about by J.D. Vance and Donald Trump. And you've already got a bill in Congress, and it looks like they're going to turn this, the Republicans are going to turn this potentially into a year-to-year issue where there's always a bill in the House to pass this, and maybe they can get momentum, even though they don't have 5 justices for it. By being so close, the issue has remained alive and remains a political football.
Yeah, I think you're absolutely right. Although I think now after Wong Kim Ark and now after Trump v. Barber, the issue of whether or not constitutionally Congress can pass anything that's contrary to the 14th Amendment is a closed issue. But politically, you're right. I mean, I think they will continue to bring up the issue.
It's a closed issue so long as Justice Barrett stays with the majority. We don't actually know what she thinks. Or so long as the Chief Justice remains alive. I mean, it's pretty scary.
Well, there is something called decisis, right? I mean, Kevin.
Is there? Trump, is there? Because Trump v. Slaughter just vacated Humphrey's executor. Dobbs vacated Roe. Loper Bright vacated Chevron. I don't have to tell you that this court doesn't really care about stare decisis.
I think that's right. I mean, but stare decisis is supposed to be a governing principle, and when the 6 want to adhere to it, they decide to adhere to it. And this is this is a general criticism of the Chief Justice, because if you look at his decisions Citizens United, Shelby County, Loper Bright, SEC versus Cherkasy, Trump versus the United States, and now Trump v. Slaughter, it's clear that they are going in a direction of believing they can legislate what America should look like and have. But, there are some who still believe in stare decisis, and I think it's going to come back and bite them one day. But we'll see. There's a lot of talk about changing the court, about what things can be done to affect the what many people regard as a runaway political court.
From your lips to God's ears, whoever that is, what's up with TPS?
Okay, so just a brief history. 2010, there is the earthquake in Haiti. Even before that, Haiti had 2 coups. Many people in the Haitian community were pressing the Obama administration to give TPS to Haitians. Very, very reluctant. It was a big fight internally, which should have been a no-brainer in the Obama administration, or any Democratic administration for that matter, but became a big fight. And then the earthquake happened, and it was hard after the hurricanes, the political instability, 2 coups against President Aristide, and now we have the earthquake. It was a little difficult for them to deny TPS because Haitians meet every single criteria. If you look at the statute, it says, if there's political upheaval, if there are environmental problems, earthquakes, and so forth, hurricanes, and they had it all. So from 2010 or 2012, I always forget the date. We've had TPS. And during the first Trump administration, they tried to take it away in the same way that they did here. Trump made very vicious, racist statements against Haitians. We challenged that in Saget in the Eastern District of New York successfully. The government appealed it during the Trump administration. Then Trump was out. The government then settled the matter and allowed TPS to remain. And things just got worse in Haiti, right? Over the course of the next 10 years, with an assassination of a president, with more political instability, with gangs and so forth. But it was predictable. And one of the lawyers who has really been at the forefront, Jeff Peepoli, called me the day Trump was elected and said he thinks we're going to have to do the same thing again. And he was right. So we brought the case of the first case, actually, was a case in which the government, the Secretary Noem, cut TPS in half. And we challenged that in the Eastern District of New York successfully and got TPS reinstated until February 26th.
That's 2026. That's the heck.
26th.
The HECA lawsuit in front of arguably the most conservative judge in the Eastern District of New York.
And the judge, and that's still good law unless it gets vacated. And, in the HECA case, it was clear that there was no authority at all under the statute to just decide to cut TPS after it had been granted. So it was eventually restored to February 1st of this year. We amended the complaint several times. The last amendment was to make it clear that we were suing under not only the APA, but under constitutional theories of race discrimination, not nationality discrimination, race discrimination. And we certainly had a good enough record. The district court judge, I thought, wrote a brilliant opinion, Judge Reyes. We brought that case in the district court of the District of Columbia. The government, of course, took it up. They sought to stay in the DC circuit. That was denied. And Judge Reyes ruled both on the APA claims and on the race discrimination claim. At the same time, all these other TPS cases were going up through the court system. They were all doing it under the APA, because you may recall that under Trump v. Barber, the first time the case came around, the issue was, can you bring nationwide injunctions? And that was thrown out by the Supreme Court. You can no longer bring nationwide injunctions. And therefore, we were relying on the APA in part to set aside under Section 705, temporarily set aside, and then under Section 706, permanently set aside these termination dates. At the same time, we were still bringing a constitutional claim of race discrimination. The judge ruled in our favor on both, but another case was coming up, Dahlia Doe, which was the Syrian case where a judge had entered an injunction as well. Prior to both of those, the Venezuelan TPS cases had gone up. The Supreme Court, in its special docket for the Trump administration, as I call it, and it stays in favor of the Trump administration of orders that prevented the termination of Venezuelans. So those terminations went through, and people could be deported. Venezuelans could be deported. Of course, there's a little footnote to that. What are they going to do now with 3,900 people dead in an earthquake and many, many more displaced and so forth, as to whether or not they're going to grant a renewed TPS to Venezuelans. But putting that aside, the case goes up on Dahlia Doe. We asked the court to accept certiorari in our case. The government also asked the court to accept certiorari before judgment. And that's a very rare procedure. In other words, in Dahlia Doe, they said, well, don't wait for the Court of Appeals to make a decision. Just grant cert now before there's any judgment, and you can decide this issue because it's a purely legal issue. They did the same with us, although they conceded in our case that there was jurisdiction on the race discrimination issue. So now we have the two cases in the Supreme Court. They're joined. The first issue is, can the APA be used to review the failures of the agency to follow the procedures in Dahlia Doe? The government's argument was Section 244B5A precludes any jurisdiction in federal court. It bars jurisdiction over terminations, extensions, and so forth. Our argument was, oddly enough, a case that I had argued many, many years before called McNary versus Haitian Refugee Center, that said, even if you can't review the final decision, you can review the procedural construction that the agency used to reach that final decision. And if you look at the TPS statute, the government does have requirements about what they're supposed to do. It's not just flipping a coin and saying TPS can be granted or not. They had to, among other things, consult with the Department of State. And they clearly didn't consult with the Department of State in any meaningful way. So the argument was they didn't follow the procedures. The district court was right in setting aside determination. They can go back and do it the right way, but they chose not to, saying everything is barred. And Justice Alito, in writing the majority decision, said a determination. And this means so much about textualism and how meaningless it is. A determination is not only a determination, it's everything leading up to a determination. And therefore, everything was barred. And I thought it was, quite interesting that Justice Kagan in dissent said, well, there's something called a determination. And then there's something called other things leading up to a determination. But I guess in this court, they mean the same. And I think, poking fun at what Alito had done. But that's how they reached the conclusion that you cannot bring any challenge under the APA with respect to any termination extension. But they still had.
Before you get to what they still had, which is the equal protection, let's just talk the statute real quick. And first of all, I'm no fan of Justice Alito. I think it's clear. I think it's a laughable decision. I don't even think he believes what he was writing when he's bringing out dictionaries and describing what determination means. It's pretty weak stuff. To the Solicitor General's credit, he went into court and said, yeah, you can't review anything. We don't care how terrible this is in practice. The Solicitor General isn't playing hide the ball. You were in court. He either has a lot of guts, thinks he's got the court, or both. And I don't respect his legal theories, but I guess I respect that at least he's being honest. Before we go on, just hats off to Jeff Popoli, Andrew Tauber, the whole Brian Cave team who were our co-counsel, who really did such a heavy lift on all of this, and to Jeff since the Mayor Brown days with Sajay in 2018. Jeff got to argue for the Supreme Court, of course, with ACLU and Ahilan. Did a great job. Sejal Zota with Just Futures Law, and Raymond Audain, our co-counsel. I mean, and by the way, this cost $11 million? I don't know, whatever Brian Cave paid. It's just so ridiculous how expensive it is to litigate for the rights of human beings. It is truly a game that only the rich can play. So hats off to them and to the big firms that are putting up the money and the time during this era of the executive targeting them to do what's right. It's not a small thing, and I just think it's important to say it. On the strict, though, it comes down to the TPS statute itself. It's not a general APA ruling. It's a very statute-specific jurisdiction stripping ruling. However, I hate to be this guy, but it has always seemed to me, as you, I think, that a lot of the statutory argument rose and fell with McNary, your big win. It seems to me that the Supreme Court has narrowed McNary out of existence by saying that the ruling in McNary was very dependent on that SAW statute and the wording of that statute, which of course doesn't exist in any more INA provisions. Am I overreading that? I want to be wrong. Tell me.
Yes, you're wrong.
All right. Why?
I think you're overreading it. I think the issue of preclusion in the Dahlia Doe case and in our case and the application of McNary, I think was actually a close question. And the reason is, the procedures that were challenged in McNary involved everything about the determination. It involved due process issues, translation issues. It involved a whole series of things that made the decision very questionable. And it wasn't in the context of, really international law issues. Although immigration isn't necessarily, infected always with international issues. But here the determination stems from the original decision to allow a president to decide what he wants to do or not under deferred enforced departure, which existed prior to the TPS statute. And they saw, I think, the TPS statute as merely codifying that, but giving it certain limitations. I think McNary was a totally different kind of case.
You didn't go to law school to enter data. I know I didn't. Yet here you are. H-1B season in full swing, and your team is buried in beneficiary forms, document chasing, and data entry. That's $400 an hour in legal talent doing $20 an hour work. Staffy plugs directly into your workflow. Staffy handles the data entry, document collection, and H-1B form prep. Your team reviews it, you approve it, you bill. With the new wage-weighted selection process adding even more admin pressure this season, the firms that scale are the ones that stop doing it all themselves. Say yes to more H-1B clients without burning out your team. Visit staffy.cc or call 786-891-5619 or click on the special link in the show notes. because you deserve a practice that grows without burning you out.
I have to say, I wasn't particularly shocked, very disappointed, obviously, but I wasn't shocked at the outcome on the Dahlia Doe part. I was shocked at the second part, which was the discrimination issue.
Let's talk about that.
The record is, the Trump record. I mean, Trump said horrible things. He said Haitians eat cats and dogs, and they're eating pets of people in Springfield. They come from a shithole country. They all have AIDS.
They're poisoning the blood, but he wasn't talking about racism. He was talking about, blood poisoning, maybe too much alcohol or
yeah, exactly,
an
sure.
infection. If poisoning the blood is not racist, I've been saying,
you mean the phrase coming from Hitler and Nazism wasn't
right? They're not racist; they just hate Jews. If did Justice Alito and the majority just say it's not racist unless you use the N-word, and sub question, do you think that at least 4 justices would say it's not racist even if you do use the N-word, so long as they're from another country? I mean, I really don't know how else to read their equal protection stuff.
Yeah, I mean, there are 4 prongs to the Arlington Heights factors. He just looked at one, didn't look at the others, misread Arlington Heights, misread the burden. It's hard to believe that he did this not knowing what Arlington Heights says, or which is the standard, or not knowing how one proves a race discrimination case, or not knowing that this was only on a preliminary record. Remember, this was only a temporary set aside. We hadn't gotten any discovery, and so there was no basis whatsoever, in my view, for Alito to do what he did, and he was called out in the dissent, because the dissent listed all the things that the president in Nome had said, which was conspicuously absent from Alito's opinion. So the case goes back to the district court. It's not clear what's going to happen on the race discrimination issue because, as you point out, Kevin, I don't know what would convince them. Given what is already in the record, it's hard to believe that there are 6 justices on the Supreme Court who are sensitive to race issues. And to have just dismissed this and set it aside, given all the things that Trump had said, is hard to believe, because in Hawaii v. Trump, they the Chief Justice got around it by saying, well, these were presidential statements. These were on when he was on the campaign trail. They couldn't do that here because a number of them were made while he was president of the United States, and yet they still looked the other way. So it's pretty discouraging.
To put I hate to be so discouraging, but there's 1 million people's lives on the line with TPS, 350,000 Haitians. They're expanding private prisons, and a lot of these Haitians came in right through parole at iwi, in the jurisdictions where iwi is subject to mandatory detention. Things are about to get really scary.
I mean, we could talk about that for a long time. And my, my view, which is Trump made a promise to the American people he can never keep, which is he was going to get rid of all these criminals and everything. And of course, they represent a very, very small number of the people. So what is he doing? He's taking legal people. And by the way, it's more than 1 million. We're talking about 750,000 Venezuelans, 350,000 Haitians, and then every other country, about 13 or 14 countries with TPS, and he's making legal people illegal because he believes that TPS is not lawful, and the vice president has said TPS is not lawful. I don't know where they get it. It's a statute passed by the Congress, but the strategy is let's make them all illegal, then we can incarcerate them and deport them and say, see, we're deporting millions of people. And that's the real crime here. It's not just legally what's happened here. And this is consistent with this court. They refuse to look behind and look at the real motives of what's going on, whether it was Trump v. Hawaii, where it was clearly a Muslim ban. They continued to ignore that it was a Muslim ban, where it was in Mio here on TPS, where they continued to ignore that this was racially motivated on the part of this administration. They clearly don't want people who come from TPS countries because they're non-white people. And given the statements of Miller and Trump, it's hard to believe that the court can't look behind and see what the real motive is. And so we're at where we're at on TPS right now, and I think they're going to successfully, or at least try to successfully, do away with every single group that has gotten temporary protected status.
Ira, that was a lot. They're not all negative. And we're going to again end with a high note. I feel like I got to keep repeating it, but let's keep going. What happened in El Otro Lado?
Mullen v. Otro Lado, June 25th. Again, my point that these were all issues. Dahlia Doe, June 25th. Trump v. Barber, June 30th. Trump v. Slaughter, June 29th. They were all issued at the end of the term so that people couldn't focus on any particular one thing, given how bad a number of these decisions are. And Mullen v. Otro Lado, I take very, very personally, I have to say, more than some other cases. But this is a case involving what they call the metering policy. And depending on who you're talking to, the metering policy was, well, we were overwhelmed at the border, so we asked people to stay on the other side until we could ever get to their case. That's the government's view. The other view is they weren't so overwhelmed and they were told to lie to people and basically just push them back into Mexico. So metering may mean different things to different people, but the one thing it means is if you haven't stepped foot physically in the United States, you have no rights. So the question in the case was the metering policy in violation of Section 208A and 235A1? Was it in violation of the United Nations Convention relating to the status of refugees, particularly Article 33? Because in the majority's view, the statute required them to arrive in the United States, and their understanding of arrive in the United States had to mean physically step into the country. The first issue is the case was probably moot, as Justice Jackson points out, because in July of 2024, before Mr. Trump came back into office, which most people don't know, or he certainly doesn't credit them with, President Biden shut down the border in July of 2024. So the issue of whether or not metering was going to occur again, maybe in the future sometime, the court hung their hat on, well, declaratory relief was granted, so it could come back in the future. But as Justice Jackson pointed out in dissent, this case was clearly moot. And then the court concluded that since the applicants had not arrived in the United States, they're not permitted to apply for asylum. They also relied on the bar against applying laws extraterritorially. Justice Sotomayor issued the dissent and took exception to all of Alito's claims, but particularly the majority's characterization of metering and its interpretation of arriving in the United States. She found that arriving in the United States must be read in the context of 235A1. And when read in that context, it means to reach a destination, arriving in. And she gives examples like if you go to the movie theater and you go up to the ticket booth, have you arrived at the movie? You don't have to be physically in when you buy the ticket, right? So, she makes I think she makes a very good case for why arriving in does not mean that you have to physically step foot. And indeed, the majority recognizes that interpretation violates the principle that you cannot have a duplicative interpretation, because one of the statutes, right, they find that a person who arrives in the United States is a subset of the second statute that says present in the United States. So if arrived in meant the same thing as being present, then arrived in would be superfluous. And one of the textualist readings, of course, is that you can't have a superfluous statute. Every statute has meaning, but the way they have interpreted it now, they both in effect mean the same thing.
I don't want to belabor the point because we got a lot of cases to get to, but that's also what's worrying me. What Justice Alito's view of the canon against superfluous interpretations of statutes means, because they just held that arrive in means the same thing as physically present in the United States. And if that's what they view that clearly superfluous reading, I'm worried about when the Iwi bond issue, the matter of Hurtado issue, inevitably goes to the Supreme Court. The courts that have been disagreeing with matter of Hurtado, saying that Iwi's get a bond, have been relying pretty heavily on the canon against superfluity, or however you pronounce it, and how applicant for admission must mean something different than seeking admission. And that scares me a little bit.
No, and you have a right to be scared, particularly with the six. The thing that was most important to me in this case and most troubling, and Sotomayor does importantly recount the history. The whole point of the United Nations Convention relating to the status of refugees, it's a convention and protocol. We signed the protocol in 1967. Why do you have a refugee convention? Because during the Nazi era, when people were trying to escape, and the most well-known case is the voyage of the St. Louis that went to Cuba, went to the United States, then went to Canada. The people were turned away. They wound up, many of them dying in concentration camps. It was this notion that you shouldn't be turning away people at the border. And indeed, since Germany and Switzerland was a neutral country, maintained a border, people would go to Switzerland to try and get in, and the Swiss would turn them away. And the countries of the world said, never again. We will never turn away people at our borders who are seeking asylum. One can argue over how many of these were valid claims or not, but the principle of turning away people at the border who were seeking asylum was a solemn promise the United States made when they signed the protocol in 1967. They've now thrown that out the window. They've said, we don't care. And they're not making distinctions between good claims and bad claims. They're saying if you didn't step foot in the United States, you have no rights. And that's the equivalent of what is directly contrary to the convention relating to the status of refugees. The next case was Blanche v. Lau, which was a case really left over by Vartelis. In the Vartelis case, you may remember, they said this section 101A13C5 cannot be applied retroactively, but there was an issue there, and it was Justice Ginsburg's opinion where she says, well, even if we had to determine what can happen with these people, we can't have a court, and she talked about a Pied court, which was apparently a court in England that was spontaneously done. She said we can't have that kind of court right at the border. And so if a person has not been convicted but may be charged, they have to be let in because they're a lawful permanent resident of the United States. Justice Thomas, never giving a break to any immigrant, basically says, no, he agrees with the federal government. We don't have to make that determination at the border, because after all, if we did, then you'd have to let everybody in. We can instead parole them in. And in this case, 14 years later, in a deportation hearing, they determined that he was inadmissible to come into the United States because eventually, even though he was not convicted at the border, he was eventually convicted in the United States and therefore was inadmissible. So Blanche v. Lau is kind of an outrageous application of the concept of what 101A13C5 was supposed to do, which is, did you commit a crime? And therefore, can we stop you at the border? But if somebody gets charged or somebody believes that they committed some CBP officer believes they've committed a crime, it should not give them the right to stop them from coming in unless you have a conviction or an admission. And here in Blanche v. Lau, there was no conviction. There was no admission. They should have let the guy in, and they chose not to do so and wait 14 years and then treat him as if he's still at the border, right? Because he's been paroled in, and kick him out.
So much more to talk about on that, but what else is next? Let's go.
Okay, Cisco versus Doe. This is a very important case on aiding and abetting liability under the Alien Torch Claim Act and the Torture Victims Protection Act. Both of those acts did allow for aiding and abetting liability. This is where there are violations of international law committed abroad, and two aliens sue, or they sue a U.S. company in the United States for extrajudicial killings or aiding and abetting extrajudicial killings. The Cisco court ended aiding and abetting liability under the Torture Victims Protection Act. And as a practical matter, really ended ATS claims, alien tort claims. Why? Because in writing the opinion, I think it was Justice Barrett determined that the claims that you could have under the Alien Tort Statute are only those that were originally listed in Blackstone in violation, and they were violation of safe conduct, infringement of the right of ambassadors, and piracy. And so those are the only ATS claims. The notion that you can have a violation of international norms is now no longer the law of the United States.
Does it depend on the pirate? I mean, pirates have evolved over time as well. Did the court get to that very important issue?
I don't know. Can we consider the Iranians pirates because they're blocking the Strait of Hormuz?
I don't think you can be a pirate if you control a country. I think that's inherent to being a pirate, is that you are you're on your own. You're a man of the sea, or a woman, I suppose. But we digress.
ExxonMobil versus Cemex. This was a case that I think was quite a surprise. We have something called the Foreign Sovereign Immunities Act, and it says you can't sue a foreign sovereign, whether it's Cuba or any other country, unless you meet one of the exceptions under the act. The court threw that out, saying that the Helms-Burton law allows for suits in trafficking in property. So this is a case where ExxonMobil was claiming that its property was taken away in Cuba years ago and by Cemex, and that they had a right to sue for all the back money that they are owed because the property, it was, quote, trafficked. That is, it was either used by Cemex, which was a Cuban company, or actually in that case given to some third party to use. So it was expropriated and then used by a third company. They're saying that's out the window. We don't care that it doesn't fall under any of the exceptions of the Foreign Sovereign Immunities Act. We can sue Corporation Cemex because it's part of the Cuban government. So the Cuban government no longer has protection under the Helms-Burton law if somebody trafficked in property that was owned or used or leased by a U.S. company prior to the Cuban Revolution in 1959. The next case, the positive case that Kevin's holding on to, which shows you how desperate we all are, is Geo Group versus Menacol. This is we all know Geo is the private immigration detention company that operates immigration prisons in the United States. Geo wanted to have it both ways, of course. They want to say we're a private company when it benefits them. But when they get sued, they want to say they benefit from sovereign immunity because they're working for the U.S. And they tried to do that in Geo Group versus Menacol. The Supreme Court held that Geo did not receive did not receive derivative sovereign immunity from suit because sovereign immunity is not transferable to an agent or contractor. However, under a case called Gearsley, they can raise it as a defense if they were authorized and directed by the government to take the action. You know, this was a case where it had to do with violations of the TVPA and making people work. And if they refused to work, putting them in solitary confinement. And if they refused to work for $1 a day, punishing them. And the court said, and then after being sued, they argued sovereign immunity based on that they were working for the federal government. And the Supreme Court said no. So that's the one positive case with Trump v. Barber.
It's not nothing from my, limited experience. And
No, I think I don't, in fact, I don't mean to make light of it because I have been a very strong proponent of using the Federal Tort Claim Act and using the TVPA to sue the heck out of the government. We should be having, federal tort claim cases filed all over the United States for the thuggery of ICE and what they're doing in the country, shooting Americans, shooting non-citizens, killing people, beating people up, tasing them, whatever they're doing. Every one of those should be met by a Federal Tort Claim Act case. And the same thing is true of GEO, where they've now had more people die in custody, whether it's GEO, CoreCivic, or an ICE detention facility, than we've ever had before. More people have died since Trump came back into office in January 2025 than we've had in any previous presidency.
In the 1983 context, if you have sovereign immunity as a blanket defense, that kills a lot of these lawsuits at the beginning, because to get beyond sovereign immunity is a very big thing and it's immediately appealable. So before you even get discovery, before you even have the case, you're already on appeal if the federal court judge rules against the defendant in a 1983 lawsuit. So to say that it's a affirmative defense and not something that's immediately appealable does let these lawsuits potentially play out and get discovery a bit more. And the longer a lawsuit goes forward, the more evidence can come out, the more likely it is to settle. So it's kind of a big deal, right?
Right. And remember, we're talking 1983 applies to state actors and so forth, although there are many there too. We're generally talking about the Federal Tort Claim Act, and that act, there could be a qualified immunity, but generally they've waived the immunity in most circumstances, except some narrow circumstances regarding whether they were acting in due course or in their official capacity under certain circumstances. So I don't want to give a plug for my book, but there's a good read in my book on the Federal Tort Claim Act, and I'd urge people to take a look at those cases. There are a lot of successful ones.
And what's your book called? What's your book called? It's a new book.
I don't know. I can't remember the name of it. It's too confusing.
Kurzban's, not just Kurzban, Kurzban's.
Okay. Cert granted in 4 cases already. Sun Valley Orchards versus Department of Labor. This is an attempt to extend Jarkessi, where they say you're entitled to a separate trial. The administrative agency can impose fines. In this context, it has to do with extending H-2A fines to and penalties to H-2A violations. The second case is the big one, Black v. Decker, and it was granted in cert under a case called Gianalo v. Black. That's the case that's going to decide, is there a constitutional right under 236C to avoid prolonged detention? Remember, the federal government pulled the wool over the Supreme Court's eyes when it upheld the original idea that you could have mandatory detention for certain people who commit certain crimes in immigration by telling them it was only people were only detained for short duration. It turned out that that was a lie, whether it was intentional or not. The government went back, the solicitor went back years later and said, that was a mistake, that report wasn't accurate, and so forth. because it turns out, of course, as we all know as lawyers, that our clients stay in detention a lot longer than a month or 2 months. So the question is, if you have prolonged detention under Matthews v. Eldred, is that a violation of the Constitution? And who has the burden to establish release from detention? So the three questions are whether there is a point where an alien's mandatory detention becomes so unreasonably prolonged that due process requires a bond hearing. If so, whether due process requires the government to bear the burden, and whether this case is, the third issue is whether the case is now moot. It may be, again, Justice Jackson raising that issue and asking them to include it in the cert petition. The third case is Wasley v. Bondi. This is the one where we've had a split in the circuits, whether a non-citizen whose asylum status was previously terminated after criminal convictions are categorically ineligible to seek an adjustment of status again. And the last case, Montoya Palacios v. Liggins. This is the one I dread, of course.
Yeah.
That's whether under the EAJA, the Equal Access to Justice Act, where we're all getting fees, quote, any civil action includes a writ of habeas corpus to challenge civil immigration detention. There's been a split in the circuits on this. I didn't think they would take this, but obviously so many people are winning habeases, getting so much money from the federal government. Someone may have raised this in the federal government as a problem that the court should look at. So the court has now taken this in the very last days of the term.
Not good. Wow. We've got some aegis pending. Let's any chance that they resolve themselves before the Supreme Court rules. I don't like where that one's going to go for the non-citizen bar.
I don't know. I mean,
keep filing your aegis or no? You think they all get stayed?
Yeah, I think people. I think you should file them. We don't know what's going to happen ultimately. I think they'll all get stayed. I think the government will move to stay them pending the decision of the Supreme Court. If you have one right now, maybe you can get it in under the wire quickly. But I would certainly continue to file them. I might not spend as much time as I normally would on an aegis petition. But yeah, we don't know what the court's going to do. It's not usually a good sign. They haven't been terrific, let me put it that way, on attorney's fees for lawyers vindicating rights of clients.
I believe the last one was no aegis fees for winning a preliminary injunction or something like
Correct.
that. So,
correct.
All right. First of all, thank you so much. Thank you as always. That was wonderful.
Sorry I went over the time.
No, I mean, you didn't go over the time at all. We control the time. And by the way, we're at a great time. And if you're still listening, you're the real MVP. But I keep saying we're going to end with some high notes, some light at the end of the tunnel. And we haven't prepared this. We haven't really prepared for this at all. But I mean, what you got to have something, Ira. What? It's not all doom and gloom. What can we look forward to? What can give us some hope right now? And you're not allowed to say the midterms. Right. You listeners didn't see. It looks like you were say the midterms.
I didn't see that coming.
It looks like he was about to say the midterms, everybody.
Right. Okay. So, it really has to do with your view of the world. You can let them beat you down all the time. But I think some of the highlights of what's happened over the last year are clearly all these habeas petitions that have been filed. Clearly, people are starting to file Federal Tort Claims Act cases. I think we should not just stand for the blatantly illegal conduct. Keep filing lawsuits. You're going to have to file more. Keep filing and vigorously defend people in deportation cases. And I want to make one comment about that. And maybe this just comes from my background. People have always thought during the Holocaust, if Jews had just laid down in the streets, just resisted in some way, that they couldn't have had the mass murder of 6 million Jews that they did. And that's probably true also of the other 6 million or 8 million people that the Nazis killed. So my view is, Don't roll over. Don't leave the country because you're afraid. Fight your deportation case. If everybody fights their cases, they can't possibly deport the numbers of people that they're talking about. If you're in detention, ask for a bond hearing. If you don't get a bond hearing, ask for try to file a habeas petition. I recognize that there are financial limitations to a lot of people to do this, but that's your only choice. The strategy of Miller is so clear to me that it's to terrify people. They're happy when this unfortunate case happened with the Mexican being executed by an ICE agent. I don't know if they're happy, but they use it to their advantage because they want to terrorize the population. A population that stands up and fights, they cannot handle. Miller understands that. He can't deport millions and millions and millions of people if they fight. The only way that they can win this battle is if people get so terrorized that or deflated that they leave the country. So my encouragement to everybody, fight in any way you can. If you can't afford a lawyer, go to the hearing and tell the judge you want relief. Ask the judge for a continuance until you can get a lawyer, which is your right. And if you have relief available to you, get that relief, fight for it. And some people are going to win. I can't tell you who's going to win and who's not, but certainly if you abandon the United States, you're not going to get anything.
Two Jews talking about the Holocaust. Before I get all the hate mail, I must note that there were quite a few during the Holocaust that did fight back. Your point.
No, I'm sorry.
Your point being in mass.
No.
Before I get the hate emails, the point being is that in mass, no one could believe that if they got on the train, that it would end the way it did. Ira, you are a blessing. We in the Immigration Bar appreciate you. I, as a partner at the firm, appreciate you. 20th edition of your book coming out this fall, which you do every 2 years. So that's 40 years of preaching the immigration gospel. Thank you so much for coming on, and I look forward to talking to you again about God knows what case.
And if I can put just a plug, real quick plug on the book, because I think people should get it this time, even more than other times, because every single Board of Immigration Appeals decision, every single memo, every single policy manual input of the Trump administration, every single executive order, they're all in there up to July 1st, including all the Supreme Court cases that I was talking about today.
Which is a huge lift. You didn't get the 2 BIA ACA decisions that came out while we were talking, and I'm not going to even do
today.
While we were talking, 2 ACA decisions from the board. The board does not stop. I'm not even going to do it this week on the pod. I'm already at 9 cases. The next week it is Friday afternoon. This is insane. I'm not going to live in their world, but just a dedication to everything you do. Thank you again, Ira.
Kevin, thanks a lot. I appreciate it. And I'm a big fan. You're doing a great job.
You heard it from the goat's mouth. Have a great night, Ira. Great weekend.
Take care.
So there you have it. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli, and Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview. That's IMM Review. And we're always interested in hearing listener feedback. Like this review about the episode you just listened to from my very young son. Son, how did you like that episode? Indeed. If you, like my son, enjoyed what you just heard, again, please give the Patreon page some love, feel free to review the pod, reach out to me with your own kind sounds, or do anything else nice that your heart desires. I'll be back next week for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.